Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Here today to talk to you about Antonio Brown. Antonio Brown is a former NFL All-Pro wide receiver who was well known and recently arrested and facing some serious charges, attempted murder due to an incident back in May 16th. Where there was an altercation that broke out after a Miami event. And there's some video of the incident. It was outside of this boxing event that had happened, and seconds later of this altercation, gunshots break out. So everyone scatters, and the alleged victim is someone that he actually knew and had prior beef with. The defense attorney in this case, obviously he's filed not guilty plea on behalf of Antonio Brown, but beyond that, we know that they have filed a stand your ground motion, which is a self-defense claim that the actions that Antonio Brown took were in self-defense. And in Florida, that's totally allowed if you believe that you are in imminent danger of great or serious physical bodily harm. Now, you can't just get into a fist fight and then pull out a gun and shoot someone. So something had to happen to trigger that extra force. And the defense attorney already filed a motion for stand your ground. He also provided Antonio Brown's DNA because they want to test some evidence. There's a holster that apparently the police found that the defense claims belongs to Antonio Brown. And that's important because they want to make the assertion that if he had a firearm, and they're alleging he did because he's acknowledging when you do a stand your ground motion, you're admitting to the conduct, but that it's justified because of the circumstances. So he's not denying that he fired a gun. It's just why did he do it? And so they are seeking to have that holster tested and show that it's his and that he was lawfully possessing and carrying a firearm. Recently, a couple weeks ago, there was a hearing to see where they're at and if this case is ready for trial or what's going to happen next. And let's take a look and see what's going on there.
On behalf of the state for Mr. Antonio Brown.
Yes, ma'am. Mr. Brown's case.
Good morning, Your Honor. Mark Eiglarsh on behalf of Mr. Brown, who's present on Zoom.
Okay. Yes, I see Mr. Brown is there and present. All right. We have today.
Your Honor, as my understanding, we are set to pick a date for the stand your ground motion that was filed.
Yes.
That wasn't my understanding. We're going to be taking some depositions before that time, Judge. And I also want to get the DNA evidence that's outstanding. My client voluntarily submitted a swab recently. And if the test goes the way that we expect, we believe that that's going to undermine a significant allegation the state made. So we're wondering when we can expect that DNA evidence.
Well, let me back up. Actually, today was a date that I was going to be addressing the setting of, you filed the stand your ground motion.
Right.
And I believe from the last proceeding, I said I'd like to set a date for that.
Correct.
Now, you have other matters and discovery issues. You should be dealing with that. So let me give you a date for the stand your ground hearing.
The reason why I wanted to delay in doing that is there's some depositions I'd like to take before we have that hearing.
Okay.
And I want to get all the evidence before I take those depositions. So it comes
Okay.
back to when are we going to get the DNA evidence?
All right. Well, that's your question. And state, you have a response?
No, Your Honor, I'm not sure. I know that we did receive a DNA result, is my understanding. That was provided to the defense counsel. So I'm not quite sure exactly which DNA result he's looking for. Maybe if he can send me an email, I can provide whatever it is. It seems to be missing.
Should counsel outline and communicate directly with the state of what information you're still missing in discovery? And
The state is claiming that the swab that was taken in my office, in my presence with the agents, just a couple of weeks ago, that somehow that made it to the lab and that there's results on that, and we have been supplied that result. Is that what the state's alleging?
Judge, that's my understanding. I can double check. I know that I was in trial and the second ASA on the case was handling the discovery, but That's what my understanding is. I can double check.
The second ASA on the.
It was Miss Stephanie Cruz.
Okay.
She was present in front of Your Honor the last time the case was set for
Okay.
status.
And she needs to speak with you about things. So she didn't really have the responses either. So between the two of you, I'd like some responses.
Absolutely,
Right.
Judge. I can look into the DNA that defense counsel is asking. I did receive an email from him yesterday requesting deposition dates. I provided dates towards the end of February, beginning of March
Mhm.
for depositions. But that's all it was asked of me at that time.
Okay, so this is what you'll need to do, Mr. Argalash. I'm going to give the state 5 days to respond to the DNA question that you raised in terms of any a bit of discovery that seems to be outstanding.
Sure, Judge.
I can be
And-
even more specific, Judge. It was the holster left on
Okay.
the scene that we have submitted proof belonged to my client. That was his own holster from his own weapon for which he has a concealed weapons permit. And they went
Mr.
and DNA.
Eyeglass,
Yeah,
Mr. Argalash, I absolutely understand.
got it.
You know, as in terms of what the specifics are, there's outstanding discovery on the response specifically on the results of DNA testing,
Mhm.
right? I'm giving the state 5 days
Perfect. Thank you.
to respond and advise where the results are. And if they haven't been provided, then you'll file an appropriate motion that you think you need to file, and I'll address the motion, okay?
Will do.
And I'll
Okay.
take care of that. The next thing is setting your deposition schedule. And I hear from the state that you've been provided with some dates
Right.
to go ahead and set your deposition schedule. And so what I would ask, barring having to address any motions that either party might file, I'm going to give you one more status date. And at the next status date, I'd like you to come in, if you would, please, with some type of schedule of your depositions, that you at least set your scheduled depositions, because you just indicated you need to take a number of depositions before you can be prepared for the stand your ground motion hearing that I'd like to set. So I'd like to keep that moving along and as well handle any other discovery questions. So I'm suggesting the end of February. Unless, of course, either of you need me sooner, then you'll file a motion and I'll address it. All you have to do is contact my office. It gets on the next day.
Thanks, Judge. The end of February works for the state judge
Mm.
for another status day.
Okay. Does it work for you, Mr. Arglash?
Yeah, it depends what date, but yes, Judge, absolutely. Yeah.
Well, February 26th seems to be my date of choice today. So will that work for you?
I have a 9 o'clock in front of another judge, but I could, so I'd rather do it on a day that I don't have that, and I have an injunction hearing at 1:30. Could the court do it on the 25th? Or
We can do it on the 25th. That's fine.
Okay, so they got another status on February 25th, but you heard a few things. One, we have an issue. You heard there's ASA is assistant state attorney. Here we have not district attorneys like you hear a lot on the TV in other states. We have state attorneys, and the assistant state attorney is actually the prosecutor in the courtroom that's handling the case. The head state attorney is more of a political office. They're not usually in the courtroom handling trials. So the ASA or assistant state attorney that's covering, she's like, I don't know, the other ASA is the one that maybe knows what's going on with this evidence. And then the judge tells her, well, last time we were here, that ASA didn't know either. So the judge gave them 5 days to figure out what's going on with this evidence. So what evidence is it that the defense attorney is seeking? They want to know, they had Antonio Brown swabbed and sent over some DNA of his, a sample of his DNA, because they want them to test it against the holster. There was a holster that was left on the scene. So at the event, after the whole scuffle and everything happens and everyone scatters, there's a holster that's found. The defense attorney is saying that's Antonio Brown's holster. He legally owned a firearm. He legally possessed a firearm. He had a license to conceal carry a firearm. And so we believe that if you test that holster, that's going to go against the prosecutor, part of what the prosecutor is alleging. And part of what they're alleging is that there was some sort of security person person that was there and that Antonio Brown took their firearm and that's what was used. So he took someone else's gun and used that to shoot at the alleged victim. Why is that important? In Florida with Stand Your Ground, you don't have a duty to retreat if there is a self-defense situation. You have the right to stand your ground and not have to leave, so long as you are in a public place or a place that you have the lawful right to be and you're not engaged in any kind of criminal conduct. So if he stole someone's gun or took something that didn't belong to him, the state's going to argue he was not engaged in lawful conduct. He was engaged in illegal activity, and then therefore he had a duty to retreat, which I still think that there's a defense to that, because if the circumstances all happen real fast, even people that are engaged in criminal conduct, it's a stricter standard. But if it is imminent that serious bodily harm is about to happen to them, let's say the other guy pulled out a gun or he thought he was going to pull a gun and all he could do was to grab someone else's gun and shoot, then that is still defensible. But we don't know which of those are the situation, and apparently the allegation or the defense is saying that no, it was his own gun, he didn't take anyone else's gun, and we can prove it if you would test the holster, and we sent you the DNA. Where are the results? What are the status of that? That is pending. The other thing that's pending is the state went into this and the judge thought that, hey, we're here today, we're going to go ahead and schedule the Stand Your Ground hearing, the hearing on the motion the defense already filed. But the defense said, we're not ready for that, we want to take deposition. In Florida, I didn't know until I started doing this channel and watching other trials around the country that other states don't do depositions like Florida does. So it's not as common in other states, and it's just a given. It's where I've always practiced law. And so depositions is an opportunity for the defense attorney to interview witnesses in advance of trial. It's a formal statement. It's with a court reporter. They record everything. It would be the defense attorney, the prosecutor, and then whoever the witness is, whether it's law enforcement, the alleged victim, any eyewitnesses that may have been present at the time. And so all of that gets recorded and then can be used against them in trial, or in this case, it's a preview of what that witness's testimony is going to be. So then if they get on the stand at the Stand Your Ground hearing and they testify differently, the defense can impeach them or hold it against them if they say something different. It also could leverage any kind of negotiations in case someone at the deposition gives information that the defense could use to convince the prosecutor, hey, you guys got it wrong. Antonio Brown was just standing his ground. It was self-defense. This other guy was the aggressor. He was the initiator. He would have killed him first if he wouldn't have done what he did. So all of that remains to be seen. They set a new status date for February 25th, and then they'll be back at that point. Hopefully they'll have some depositions scheduled and we'll have a more clear timeline as to when the Stand Your Ground hearing will be, what the results of the DNA evidence is, and what else is to come. So we'll keep you posted. Thanks as always for watching. Take care.